A lot of U.S. expats wait too long to get help because they think the issue is only about paperwork. But offshore tax problems are usually not just paperwork. They are about timing, disclosure, risk, and how to fix the problem without making it worse. I'm Anthony N. Verni. I'm a U.S. tax attorney, CPA, and MBA. I help Americans abroad resolve offshore tax problems involving missed filings, FBAR, FATCA, Form 8938, foreign investments, and IRS representation. Today I want to explain how a U.S. tax attorney helps expats fix offshore tax problems and why legal strategy matters once foreign reporting issues affect multiple years or multiple forms. The first thing to understand is that offshore tax issues are rarely isolated. A missed FBAR may also mean omitted income. A FATCA issue may also involve Form 8938. A foreign mutual fund may trigger Form 86221. A foreign corporation may involve Form 5471. That means solving one form in isolation is often the wrong approach. What a tax attorney does first is diagnose the full problem. What was filed? What was missed? How many years are involved? What foreign assets exist? Whether income was reported, whether the IRS has already made contact, and whether any correction path is still available. That is very different from simply preparing a current year return. The IRS continues to maintain filing requirements for U.S. citizens and residents abroad, including worldwide income reporting and international information returns where applicable. That means normal financial life abroad can create a filing posture much more complex than many taxpayers realize. Another area where legal representation matters is streamlined filing. The IRS continues to state that streamlined procedures are only for taxpayers certifying that their failure to report foreign financial assets and pay all tax due did not result from willful conduct. That means the facts, the history, and the explanation all matter. This is not just about assembling forms, it is about making a defensible submission. Timing is another major factor. Once the IRS sends a notice, begins an examination, or otherwise identifies the issue first, the available options can change. That is why offshore tax problems should be reviewed before taking corrective steps blindly. I also see many expats make self-inflicted mistakes. They file late forms without understanding the legal implications. They submit a weak, non-willful statement. They focus on one account but ignore related income. Or they assume that because a foreign asset is routine in the country where they live, it must be routine under U.S. tax rules. That assumption causes a lot of trouble. A tax attorney helps organize the entire offshore picture and choose the right path. In some cases, the right answer is streamlined filing. In some cases, the issue requires a different approach. In some cases, the first step is responding carefully to an IRS notice rather than making a rushed submission. This is why many U.S. expats eventually search for an IRS tax attorney, expat tax attorney, or offshore tax attorney. They realize the issue is not just about getting compliant. It is about getting compliant in a way that is accurate, strategic, and defensible. A good offshore tax strategy also means understanding how the pieces fit together. FBAR, FATCA, Form 8938, foreign income, basis reporting, prior year filings, disclosure timing, all of those pieces can affect one another. The goal is not just to file something. The goal is to fix the issue in a way that reduces future risk and stands up if the IRS reviews the matter later. If you are dealing with offshore tax problems, missed foreign reporting, or uncertainty about the right IRS strategy, do not wait until the issue becomes harder to fix. If you need help understanding your options and building a path forward that matches your facts, tap the link in bio to book a consultation.